New Mexico Real Estate Basics. In New Mexico, if a broker wants to become a property owner's authorized leasing agent, a disclosure of basic broker's duties must be made prior to generating the contract. A current written agreement is required to be on file with the broker's qualifying broker. Written property management agreements or comparable written authorizations signed by the owner or the owner's authorized agent are required before any brokerage is allowed to represent the owner of the property. What must be included in the management agreement? First, the agreement must specify whether the property will be operated in the name of the owner or the brokerage. The manager and owner should spell out the structure of their relationship, their specific responsibilities and liabilities, the scope of the manager's authority, fees, and the duration of the management agreement. Property managers generally have broad ongoing authority as general agents. While New Mexico law does not go into greater detail, property management agreements should include a proper identification of the property, all terms and conditions under which the property is to be managed, and the powers and authority given to the broker by the owner. The terms and conditions under which the broker is to remit property income and whence periodic written statements of property income and expense are to be forwarded for owner review must also be included. Additionally, the management agreement should address the following: authorization for payments to third parties, brokers' compensation for services rendered, required dollar amounts for security deposits, an effective date of the agreement, terms and conditions for termination of the property management agreement, signatures of the broker and owner or authorized representative. How are the owner's funds treated? The qualifying broker is required to deposit all funds received on behalf of the owner into the qualifying broker's trust account as soon after receipt as possible. Management fees may be withdrawn from the owner's account when the basis for computation can be determined in accordance with the management agreement. When withdrawn, the funds are deposited into the broker's business operating account. The qualifying broker must always create a paper trail. As previously mentioned, see C.17. The qualifying broker who manages rental units is required to maintain a separate property management trust account. Antitrust laws. Does New Mexico have an antitrust law? No. At the present time, New Mexico operates under several federal laws. The Sherman Antitrust Act prohibits any contract or conspiracy to restrain interstate or foreign trade. It also prohibits monopolies. The federal Clayton Act regulates unethical practices that may be harmful to fair competition. In real estate, harmful practices include boycotting, price fixing, and tying agreements.